So, the ideology of liberalism has given the birth to the capitalism. And in capitalism, there is a minimal role of state in the economic affairs. And because of that, there was a large scale exploitation of the laborers and the working class. Next, you might be also knowing this famous personality, the Karl Marx, who was the German philosopher, and what he gave the idea of the socialism. So, what the Karl Marx has held that during the capitalism, the exploitation of the worker is at its peak. But this kind of over exploitation will not be continued for a longer time. The worker class in future will going to start the struggle, the revolutionary struggle against the capitalism. And at that time, the capitalist will be defeated by the worker class. And according to him, then there will be a birth of the socialism. So what it mean by the socialism? Socialism, it simply means that there is a role of a state in the ownership as well as for the production and the distribution of the resources. Karl Marx has further suggested that when this socialism will be continued for a long time, then there will be no any classes. And that is why he advocated for the classless society. So state will take a participation for the production and the distribution of the resources, and at its end, if we look into the at its extreme side, then there will be a classless as well as a stateless society. When I say the classless, it means there is only one class, that is a worker class. So at its far left, there will be a birth of communism. So communism is nothing but a classless and a stateless society. However, I would like to make an attention here that whatever the imagination that has been made by the Karl Marx, that was not practical. The communism that has been proposed by the Karl Marx has never been implemented, or it was never in a practice in any of the world or in any of the country. The communism, you can say that one of the example of the communism was at the time of a Mao. But however, there is also a class that is not the worker class, but that has the control of the state in the means of a production and the distribution. So it has been said that we consider this as a political spectrum also, and many of the ideologies in the political also being placed between this left and right spectrum. You might be aware of some parties, we call it as a leftist, okay, who might someone we call it as a rightist, okay. So on in all, that political parties are following any of the ideology that might be a liberalism, or it might be a socialism, communism, conservatism and fascism. So I would just like to say that the extreme left of socialism is the communism, and the extreme right of conservatism will be what? The fascism. And whenever we reach to the extreme right or the extreme left, okay, we are ultimately under the authoritarian government. Or in simple word, it will be a dictatorship. Now we would like to ask the question that where you will put the India as a country in this political spectrum. Does the India has adopted the concept of liberalism? Means when I say the liberalism, it means the capitalism, or the India has adopted the concept of the socialism that has been proposed by the Karl Marx. Again, I would like to say that Mahatma Gandhi was also a proponent of the stateless society and the classless society. When we say about the India, instead of going with a pure socialism concept or a pure liberalism concept, when we are going to talk about the Indian socialism, it will be the blend of both. We have adopted some capitalist approach in our economic activities, and apart from that, we have also adopted the concept of socialist approach. And that is why the India has adopted the mixed economy, where there will be a participation of the state as well as the private participation in the economic activities. Many of the authors referred the socialism of the Indian form as the Fabian socialism, or we call it as a democratic socialism. Why? Because the objective of the Indian socialism is to make a welfare state. So this is one of the concept, that is a welfare state that we have adopted in our constitution. So whenever we say that which socialist approach that we have adopted, or it is being adopted by the makers of the Indian constitution, then we can say it as a Fabian socialism. Why Fabian socialism? Because the state is involved in the economic activities. Apart from that, one of the main objective of the state is to be a welfare state. And when I say the welfare state, what the state tries to thrive? It tries to thrive the differences, it tries to eliminate the differences between the haves and haves not. It tries to establish the sort of the egalitarian society in the India. And that is why when we see some articles that has been there in Indian constitution, where you can see that the blend of the socialism, let's say for example, the fundamental right in part 3 of Indian constitution, the very first fundamental right that has been given is article 14, which talks about the right to equality, the equality before law and the equal protection of the law. When we say article 15 and article 16, it discriminates the prohibition. Article 15 discriminates the prohibition on the basis of race, caste, sex, place of birth, and religion. Article 16 talks about the equality in opportunity in a public employment. So we say that these are the rights that has been given to the group of people. Article 17, to abolish the untouchabilities in any form in the Indian society. So you see that the fundamental rights are not only providing the rights against the state, but it also provides the or it also secures the rights against the private entity. So any particular person, when I say the person, we consider it as a private entity, we cannot consider it as a state. So any person are not going to practice the untouchabilities. Otherwise, he or she will be punished by the law of the land. So this all, the fundamental rights that has been given in Indian Constitution, in the Part 3 of the Indian Constitution, have some sort of the socialist nature of Indian polity. Article 21, right to life and the personal liberty. What says that in preamble? The liberty of thought, expression, belief, faith and worship. Article 21 that has been amended in 86th Constitutional Amendment Act has provided the right to free and compulsory education to the children below the age group of 6 and 14. So previously that was a part of directive principles of state policy, where these directive principles of state policies that are available in a Part 4 of Indian Constitution, they are not enforceable by the court of law. However, the fundamental rights are enforceable by the court of the law. So if any of your fundamental right is being infringed, or if it is being taken away by the state, or let's say for example in some case some private entity, then you can approach to Supreme Court under Article 32. You can approach to High Court under Article 226. Whereas in the Part 4, the Constitution of the India has given some sort of a directions that will lead the state to be a welfare state. And that is why they have provided various articles. I cannot rather include all these articles, but there are some of the articles which has the socialist nature in the Indian Constitution. Let's say for example Article 38, so which talks about securing the justice, that has been given in the preamble. The securing the justice in the same manner that has been given in the preamble, that is a social, economic and the political justice. I will talk about this, the concept of a social democracy that has been said by Dr. B.R. Ambedkar on his Constitution Assembly speech, and he defined what it means by the social democracy is, and that was ultimately enriched in the Article 38. Article 39 provides for the avoid of concentration of the wealth and equitable distribution of the resources. Right. Article 39A that has been amended in 42nd Amendment itself, and they have provided free and legal aid to the disadvantaged classes. So there are lots of articles, and you see that if we see the progress of India, the policy of India from since its independence, we see our first Amendment Act that has been made in 1951. That was related to what? To secure or to make the India as a welfare state. In the first amendment, there are some articles that has been added. We created the 9th schedule in the first amendment. And that 9th schedule has been kept out of the purview of the judicial review. Later on it has been invalidated by the Supreme Court, but this is the first amendment in 1951 itself. We have added Article 15 Clause 4 that provide the educational facilities to the backward class, the SCs and STs. We have added Article 16 Clause 4 which secures the public employment to the backward class. And recently you see that the Supreme Court of India has given the judgment to subcategorize the backward class, that is SCs and STs, to achieve the ideals of, to achieve the goal of what? The social justice. Because Within a scheduled caste and scheduled tribe also, there are some communities who have not taken the benefit of reservation. Their representation in the public employment is minimal. And that is why the Supreme Court has taken a reference of just this justice that has been provided in a preamble. A very first justice will be the social justice. And Article 16 Clause 4, they have allowed the subcategorization of the scheduled caste and the scheduled tribe. So this is the very first amendment that has been made, and you see that if we need to compare the Constitution of USA and Constitution of India, the first amendment in the India is related to the socialist aspect for the abolition of the zamindari. The ninth schedule has been created to secure the law that has been made by the state in respect of land reforms, because the land is a state subject. Only state can make a law. And for the equitable distribution of the resources that has been provided in Article 39, the state has to make a law for the land reforms. And very first task that has been done by the state is to the abolition of the zamindaris. They have put the limit, the selling limit on the land holdings. So this is how those who have the large proportion of the land, okay, they can be taken up by the government, and that can be distributed to the landless laborers. But in Constitution of the USA, the very first amendment, they have introduced the concept of secularist approach. In the first amendment itself, they have established the free exercise and the establishment clause that is related to what? The secularism that we will talk in few minutes. Then after the government has done the nationalization of the various banks, because again, if you see the era before the 1970s, the banks are being held by the private entity, and they are using the bank for their purpose or for their benefit only. And that is why the government has suggested what? The nationalization of banks. So these are the aspects: the abolition of the zamindaris, the nationalization of the bank, the reservation policies for the backward class. This all relates to what? The socialist aspect. There will be always a question that it was the requirement to add the socialist word in the preamble of the Indian Constitution, because if you will look into the history of India between 1947, or rather clearly 1950 to 1976, there will be many of the amendments or any of the public policy that has been designed. It is solved to establish the state as a welfare state. This is what the main theme of the socialism. So this is a debatable issue. We are not going much in detail, but you can think on it your own. Okay. But what the current the discussion is nowadays going on that because you see that currently we are living in the era of liberalization, privatization, and globalization. India has adopted this liberalization post 1991. We have opened our economy to the globe through the concept of globalization. So you can be thinking that, or it might be a question that, is the role of state declined after the 1991? Because privatization is happening. The globalization is inevitable. And there is a need of liberalization to grow the economy. And that is why in the same light, a few months ago, the Dr. Subramaniam Swamy, who is a member of Rajya Sabha, has filed the PL to the Supreme Court that we should remove the term that is a socialist and secular from the preamble of the Indian Constitution. Right? So we need to understand that. So if such kind of a question that will be there, till like, right, do we need this socialist aspect in terms of this large scale privatization, globalization and the liberalization? You can also refer the labor codes that has been enacted by the government recently. But in my opinion, there is still the persistent role of the state. Let's say, for example, India is not a country where the developments are equally distributed among the states. The India can be, in terms of a development, divided into a two corridors. One will be a blue corridor and the another will be the red corridor. The blue corridor will something that the development is happening. Let's say, for example, some part of Gujarat, Maharashtra, Tamil Nadu, Andhra Pradesh. Whereas the red corridors where this development activities is minimal. It might be considered as a Naxalite areas in some part of Maharashtra, Odisha, Jharkhand, Chhattisgarh. So it will be the responsibility of the state to do the developmental activities in such a red corridors. Again, the concept of welfareism is only to be promoted by the state. The private entity cannot foster the concept of welfareism. And that is why we have, let's say, the various the public policies that has been announced by the government that will, starting from, let's say, the Manrega, National Rural Health Mission, Swachh Bharat Abhiyan, the recent, the kind of a public policy that has been announced by the government, that is the Ayushman Bharat. So all this kind of a welfareist policy is to be promoted by the state only. And last but not least is the protections of, let's say, for example, minorities. Protection in terms of the exploitation. Let's say in a various infrastructure model, in a various infrastructure project, we have adopted the concept of PPP model, that is public-private partnership. So where the state has a particular role to do the monitoring only, whereas the developmental activities is being done by what? The private entity. But that monitoring is essential, right? So this term socialist, it matters, and that is why the Supreme Court has dismissed the plea to remove the socialist and secular terms from the constitution. The Justice, the Gavai sir, has asked the Subramaniam Swamy sir that, do you not want to be the India as a secular? While hearing this case. So you can think at your own and you can read the relevant articles why still in this era of post-1991 the socialism matters. Now coming to the next term, that is a secular. And when I say the secular in a simple term, what you can define the secular as? A separate wall between the state and the church. When I say the church, I mean that a religion. So state is going to adopt the religious neutrality. The state will have no religion. The state will have no religion. If there is a concept, then we can say that the India is a secular. Now, if we talk about, or if we try to compare the secularism of the Western country and India, we can just we can differentiate it with the two secular nations, that is the US and the French. So when I say the French is a pioneer of secularism. French has adopted the complete separation between the state and the religion. Whereas, if you will look into the US will have some distance, rather it has been said it as the arm's length distance between the state and religion. Now, what it means to that, a complete separation between the state and religion. The state will not interfere in the religious matter. The state will not interfere in the religious matter. It has been said in US that arm length distance. It means at some aspect the state will interfere in the religious matter. Now this is a Kennedy versus the Bremerton School case where a coach was like doing a prayer at a public place, that is on the ground of the football, and the authority has denied, and it has said that it is against the establishment law of the USA that has been done in a First Amendment. And this case is on the year 2022. And that is why in 2024, the UPSC mains, the UPSC has asked the question, compare the model of secularism of USA and compare it with the India. So it is very essential for us to not only understand what the India has adopted in terms of this nature, whether a socialist or a secular. We also need to look into some, we can say that the state-of-the-art countries where this terminologies is being pioneered. Now, the total separation between the state and religion can only be happen if the society is homogeneous. And that is why you see the French, when French has been liberalized in a French Revolution, the French society was the homogeneous. But nowadays, due to the invent of the globalization and a large scale migration, the country are now in a stage of a multicultural stage. And that is why there is always a debate that the West has to learn something about the secularism from India. Why? Because if we look into the Indian model of secularism, it is not a separate or a complete wall between the state and religious. The state, in some manner or in some matter, let's say for example, in morality, in public health, or in public order, state will interfere into the matters of the religion. And that is why we define the Indian model of secularism as the porous wall of a separation between the state and the religion. Now, what it means by the porous wall? Sometimes the state can interfere in the matter of the religion. So there are a lot of the issues that, the articles that through which we can ensure that the India is providing, let's say for example, a freedom of religion to the citizen, but apart from that, the India is also interfering in the freedom of that religious matter. So the Indian secularism is characterized by its inclusive and the pluralistic approach, which seek to harmonize what the rights of individuals and the communities within what the multicultural society, a multi-religious society. And that is why you see that under Article 17 we have abolished any form of untouchabilities, because the untouchabilities was the practice of Hinduism. It was mainly practiced in Hindu religion. Article 25 to 28 is conferring the right to freedom of religion. But if you will look into the content of Article 25, 26, 27, 28, you will identify that there will be always the restriction that has been made in the constitution. The freedom of religion has been restricted with many of the exceptions. It will be a public health, it will be a morality, it will be a integrity of the nation, it will be anything. And by the time, if you will look into the history, the Supreme Court of India, that is the interpreter of the constitution, they have in a various judgment has interfered in the matter of religion. And that is somehow questioned whether the India is really a secular nation or not. Article 25, 325 and 326 talks about what? The right to vote. Article 326 says that everyone should be entitled to right to vote. That is as per the adult suffrage, universal adult suffrage. And no one should be discriminated to authorize their rights to vote on the basis of religion. Article 15 prohibits the discrimination on the basis of religion. Article 16 prohibits prohibits any kind of inconsistency in a public employment on the basis of religion. Right? So these are some various cases that you it has over a period of time has touched upon the very concept of secularism. Okay, let's say for example a very famous case that has been concluded by the Y.Y. Chandrachud. Our the last CJI D.Y. Chandrachud. Y.Y. Chandrachud is the father of the D.Y. Chandrachud. This matter, the Muhammad Ahmad Khan versus Shah Bano case, we famously known it as a Shah Bano case, Shah Bano Begum case. It was just a matter of the maintenance, but this judgment has given the impetus to the secularistic aspect of the Indian secularism or Indian secularistic aspect. So in this particular judgment, what the Supreme Court has, specifically the CJI, Y.V. Chandrachud says that the personal law in a matter of, let's say for example, the public gender equality or the public morality, the personal law will not prevail over the constitution. In another term, the constitution will prevail over any personal law. There was a Sabrimala case. Okay, so under some trust act by that Lord Ayappa temple, they are denying the entries of women during some time between the 5 to 40 years of age. And Supreme Court has invalidated that trust act. CAA is again, we can say that nowadays the issue which question about the secularism aspect of India. So what you can see that you can look into this, all the cases like the recent judgment that we have seen is about the Babri Masjid. So you can ask the question to yourself, is the verdict of Babri Masjid is against the secularist approach of India or not? That might be a question in future. So you must have to know why the Supreme Court has taken this view. I would say that in this Ram Mandir case, the Supreme Court has not legalized the demolition of Babri Masjid. And that is why within this area they have provided the 5-acre land for the development of the mosque. And when you will see in a social media that after this Ram Mandir verdict, means a Babri Masjid verdict, the people are demanding the Krishna Janmabhoomi in Mathura. Against what? The Shahi Idgah. The kind of the pleas, the messages are going on in for the Kasi temple. But we need to, as a aspirant, when we are trying to join the bureaucrats by clearing the examination, we need to understand that the Supreme Court has upheld the Place of Worship Act 1991. And what the Place of Worship Act 1991 says, that any of the place, whether it is a temple, it is a mosque, it is a gurudwara, or any other place of worship, whatever the position of that place was there in before the independence will not going to be altered. It is not going to be changed. So if before the independence, if there is the Shahi Idgah, then you cannot claim that to be as a Krishna Janmabhoomi as per the Place of Worship Act of 1991. The question of Babri Masjid was before the it was before the independence, and that is why if you will see the section 7, or I think section 5, I'm not sure about that, but if you will see the section 5 or section 7 of this Place of Worship Act, then they have exempted this Ram Janmabhoomi from the Place of Worship Act. So you might be questioning that, does the Supreme Court will consider this issue as like the Babri Masjid issue? The answer is no, because Supreme Court has already upheld the Place of Worship Act in 1991. You can also look into this, the judgment of the Karnataka High Court, where the few people has been they have denied to wear the hijab, and this issue is currently going on in the Supreme Court. Let's see what the judgment will be. But what we need to understand, whether it is the Supreme Court or the governance of the country, we have to justify that still the secularism, the term secularism matters for India. It has maintained, because nowadays in this multicultural area, the Western countries are, let's say for example, adopting the concept of Indian secularism. Like recently the Supreme Court has suggested that some form of, let's say for example, the worship is permitted in the public places. So these are all the kind of a judgment. There are some important judgment that, let's say for example, in Kerala there is a Emmanuel versus the state of Kerala in 1986, where the Supreme Court has given that the people has the right to be silent. Some student has been expelled from the school because they are not singing the national anthem. And they reach to the Supreme Court, and Supreme Court has given the judgment that the right to silence is a fundamental right under Article 19, Clause 1, Clause A. Similarly, in S.R. Bommai case, if you will see in 1994, S.R. Bommai has declared the secularism as a part of Indian Constitution. That is a basic part of, a basic structure of Indian Constitution. And it has been said in a case 1 and the Bharti case that a parliament is empowered to do the change in constitution. Parliament can do any change in the constitution, but they cannot do the change they cannot alter the basic structure. And in S.R. Bommai case, the secularism has been declared as what? The basic structure of Indian Constitution. Right? Similarly, you see that the Aruna Roy versus the Union of India case, where the Article 28 has been interpreted. There is a difference between the religious education and religious instructions. A student belong to any particular religion has a right to know about their religion. And that is why this Aruna Roy versus the Union of India case 2002, the Article 28 has been limited. It does not prohibit the study of religious in a cultural way. And in light of that, we can also compare this with, let's say, for example, this 1961 judgment of Supreme Court of USA in um, the Eagle versus the Vieta case. Sorry, it is uh, Vieta case, where they have completely prohibited any sort of a religious instruction in the public institutions. So you can make this kind of a comparison between the secularism aspect of US and the India. Similarly, this is a 2017 case on Saira Banu versus Union of India. We generally famously know this as a triple talaq case, and where it says that personal law must comply with what? The secular and the egalitarian spirit of the constitution. So whenever there will be a constitution, the provision of the constitution is there, the personal law will not prevail. And when I say the personal law, it's not only the Muslim personal laws, it might be the Hindu personal laws, it might be the Christian personal laws, or any religious personal laws. Right? So these are some the kind of a judgment that has been given, the landmark judgment that has been given by the Supreme Court, and you must have to read this to understand the very secularism aspect of the Indian Constitution. And that is why I would like to summarize this secularism. Like, the Indian secularism does not separate the religion from the state. And that the term that has been rightly said by Professor Bhargav, that a principled distance secularism. The Indian secularism is the principled distance secularism. Now, what it means by a principled distance secularism? The personal law varies on the basis of what? The individual's religion. Islamic Central Waqf Council and many Hindu temples nowadays are being administered by the government. Under what? The Religious and Charitable Endowment Act 1951. Apart from that, we have the 7th schedule where we have a 3 list. One is a union list, one is a state list, where only the state government is empowered to make a law. In a union list, only a union government is empowered to make a law. And we have a concurrent list, where both a state and union government is empowered to make a law. And you see the 7th list, in a concurrent list, the religious institutions, charities and trust are the part of the concurrent list, where both the state and union can make a law. So this concept of secularism in context of India is very dynamic, and you might be expecting the questions in rather a prelims or mains for whatever you are preparing for. And now we are coming to the 4th term, or the 4th keyword that has been characterizing the nature of Indian polity. That is what? The democratic. Now, the democracy has been made up of 2 words, demos and kratos. So demos means men and the kratos means power. So it means that the power of people. The demos means people and the kratos means power. So what it means by democracy? The democracy it means by what? The power of people. So we are, let's say for example, authorizing the power in the democracy by means of what? Now generally, in a political system, the democratic system can be divided into the 2 parts, or it can be bifurcated into 2 ways. One is a direct democracy and another is the indirect democracy. Like in any of the larger, the country you see, the political system you see, they have adopted the concept of indirect democracy. Say for example India, US, France, England, many other countries. So what it means by the indirect democracy? We also call it as a representative democracy. In a public policy or in a lawmaking process, the people of India is electing their representatives. Let's say we are electing the MPs at a Lok Sabha and we are electing the MLAs at the state legislative assemblies. So they are being elected by us, and that is why they are the representative of the people, the representative of their respective constituencies. And on behalf of the people of India, these representatives, i.e., the MPs and MLAs, will do the business in the government. When I say the business in the government, it means that they are making the law and they are implementing the law, because India has adopted the parliamentary form of government. And in the parliamentary form of government, the executives are the part of legislature. So indirect democracy or a representative democracy has been being adopted by the various larger countries. Whereas there is a concept of a direct democracy where the people will take a part in legislative process. So you might be thinking that how the people of the country could take a part in legislative process or lawmaking process. So there are various tools that we need to understand. Let's say, for example, referendum, recall, initiative, plebiscite. So these are the tools that is being used by the government for the concept of direct democracy. But this concept of the fully direct democracy is only possible in the smaller countries like Switzerland. They are having a concept of direct democracy. So we need to again understand the meaning of each and every term. And again, I would like to just say that when there will be a direct democracy, the participation of the people in the lawmaking, it doesn't mean that the elections is not being carried out there. There is an election. There is a representative of the people. But apart from that, the people of the countries are taking part in lawmaking process. So let's say there is a referendum, and I will also take some examples where a few countries are also practicing this. They are practicing some tools of direct democracy, or they have practiced in past, right? So referendum means what? If a government is making any law, okay, then this law will become act only if there will be the consent of the people. And that is why, for let's say any particular law that has been made by the government, they are taking the referendum of the people, whether you are whether this law is appropriate or not. So it is nothing but the kind of a voting, right? Let's say the Switzerland has recently, means not recently, but in 2021, they have passed the referendum for the COVID-19, and the kind of a protocol and the kind of a restriction that they need to apply. They have just taken the referendum from the people that we are providing this kind of restriction during the COVID-19, right? The second is initiative. It might be possible that the people of the country may initiate some law or may suggest some law. What is the difference between referendum and initiative? Here the government is making the law and then it is presenting before the people. Here the people are proposing the law to be made by the government. So we call this as what? The initiatives. Then the third tool, that will be a recall. Like if any of the representative in the government is not working according to the will of the people, they have a right to recall them. Okay? It's like in Indian politics, we do elect the people, and let's say we are electing the MPs from our constituencies, and now this MP will be stayed in let's say a Lok Sabha for 5 years, right? Irrespective, let's say for example, he or she might not be indulged in any other unlawful activities, but if he is not doing the work according to the will of the people or according to the promise that he or she has made, then people of the India or people of this constituency has not right to recall them. Okay? They have to wait for the next election. whether to select or to re-elect this person or not. Whereas in a direct democracy, this concept will be there, the concept of recall. And again, the plebiscite is again on a particular, let's say, a political issue. They will also take the view of the people, right? So, say for example, when Britain want to exit from the European Union, they have taken the plebiscite. They might call it as a referendum or a plebiscite, but majority of the newspapers are referring it as what? The plebiscite. If I talk about the concept in India, the we have, let's say for example, merged the princely states. So we have a princely state in Junagadh. So Junagadh princely state, in the Junagadh princely state, the Sardar Vallabhbhai Patel has conducted the plebiscite, right? In 1961, the Goa has been liberalized from the Portugal. And now there was a question whether, as per the Article 2 of Indian Constitution, any of the acquired territory, so that acquired territory, that was a Goa. Now the question was whether to make this Goa as a part of Maharashtra or to make it as a separate union territory. And you see that there was a Goa opinion poll that was taken in 1967, which is nothing but the referendum. Which is nothing but what? The referendum. And the people of the Goa has decided to be it as the union territories. And later on, if you will see, in 1987, the Goa has been converted into what? The state. Right? So it doesn't mean that, like, it might be questioned that the country or a polity that is following the representative democracy does not use the direct democracy tool. They can use, but they cannot make that as a tradition. But there are some countries, they have meditated as a tradition. Let's say for example, I took an example of France. If a president of the France need to sign any international treaty, they have to take the referendum. Any bill to be introduced in France that is related to a social security, let's say for example related to pensions, then that bill must be referred to the people. That bill must be referred to what? The people. So many countries are using, what is your task? Your task will be what? Out of this four, let's say for example, a dimension, what we can do or what we can adopt in India to make our democracy more representative. Or whether we should have to ask the question first, does the democracy in India is representative or not? Right? Like one should say that we have to implement the concept of recall, but as it has been suggested by one of the law commission the report, the recall will not be feasible for India because there was a large scale expenses in election system, and the population of the India is not much matured. They are diverse in terms of their let's say the political ideology. So this concept of recall, if we are implementing in India, it is being exercised on every month, let's say. So every month the representative is being recalled and a fresh election has to be carried out, which is not feasible. Like in Constituent Assembly, when there was a discussion, as I told you, that there was for 1 year a close by close discussion of every provision of the Constitution has been made, right? And there was a discussion about Article 356 that was related to the President rule. And at that time, Dr. B.R. Ambedkar said that the Article 356, that is what the President rule, is a dead letter. It means that this article will never be never going to be implemented by the Union. But you see that Article 356 is the widely used article in the entire Constitution of India. Right? So this is all about the democracy, and we are having a representative democracy. There are various reasons like uh, a large population, diverse areas. We have, like, India is divided on the basis of a religion. India is divided on the basis of what? The religion. Okay, at a time of independence, we have this. We have also experienced what? The partition, and partition will be totally what? On the basis of the religion. So again, there will be a trust issue between the majorities and the minorities, right? So as I told you earlier that in this Constituent Assembly on 25th of November, before the enactment day of this constitution, the Dr. B.R. Ambedkar, the chairman of the drafting committee, and we also call it as the father of modern India, the architect of the Indian constitution, he talked about something called as the social democracy. See, Article 326 entitle us to do the what? We have a right to vote, and with that we can able to achieve our the political democracy. But what the B.R. Ambedkar has emphasized on more on the social democracy, and what he says that the political democracy cannot last unless there lies at the base of the social democracy. And he further defined what it means by the social democracy. It means that the way of life which recognizes the liberty, equality, and fraternity as a principle of life. They form a union of Trinity. Like, you cannot see them as a separate entity. Liberty cannot be diverse from the equality. Equality cannot be diverse from the liberty. No liberty and equality can be diverse from the fraternity. And without equality and liberty would produce what? The supremacy of few over many. And he rightly said that, like, on 26th January 1950, where we are implementing the Constitution of India in this land, we are entering into the life of contradiction. In politics, we will be recognizing the principle of one man and one vote and one value. But in our social and economic life, we shall, by the reason of our social and economic structure, continue to deny the principle of one man and one value. Because the India has a full of social inequalities. Apart from that, the heinous practice of untouchabilities and the after effect of the partitions, the communal violence. So if we continue to deny it for a long, we will do so by only putting our political democracy in the peril. Right? And that is why he again said that by getting this independence, we have lost the excuse of blaming the British for any wrong that we are now going to do. Okay? So this is what the concept of the social democracy that has been emerged from this the speech of Dr. B.R. Ambedkar, and that is why you see that in this preamble of the Constitution, we say that we provide the justice through what? The liberty, equality, and the fraternity. Okay? And now the last word, that is what? The Republic. We celebrate the Republican Day on 26th January 19. It was 26th January 1950 was the first Republican Day for India, and that is what we are celebrating. But what it actually mean by the Republican Day, that the head of the state is elected by the people, not the hereditary. So like in a Britain, the head of the state is a crown or a queen. So crown or a queen are the hereditary in nature. Whereas the head of the state in India is the President of India, which is being indirectly elected by the people of India. Right? So on 26th January 1950, we become what? a republican nation. So these are, we can say that the nature of the Indian constitution or Indian polity at all. Okay? And now we will just try to briefly look into what the kind of a goal and aspirations that um, the constitution of India is striving to. Very first is a justice. As I already told you that justice is something important to have the social democracy in this country. And this order is also very much important. The justice will be what? And again, it has been mentioned in Article 38 that justice should be provided in this order only: social, economic, and the political. So when I say the social justice, it means what? Let's say providing education. And that is why in a very first Amendment Act, we have included the concept of reservation. We have included the Article 15 clause 4 and Article 16 clause 4 that will give the reservation in education and the reservation in public employment to the backward class of the society. And subsequently, if you will see in the further amendment in the constitution, we have added Article 15 clause 5, which is for providing the reservation for in education for what? The OBC classes, the other backward classes, or SEBC classes. In 103rd amendment, we have come across the concept of the EWS, the economically weaker section. Okay, and that has been added in Article 15 clause 6 and Article 16 clause 6. That was a recent amendment with respect to the say for example with respect to what? The reservation, economically weaker sections. So if the people will get the social justice, it means, let's say, the education, okay, then they will be economically empowered. And if they are economically empowered with the education, then definitely they can enjoy their political democracy. They can make a decision on their own. They can make a decision on their own that which representative I'm going to send to, let's say, the Lok Sabha and the state legislative assembly. So this order matters. Rather, if person is being economically empowered without education, possible. There are cases are there where the person is being economically empowered without education. They cannot enjoy their political democracy, or they cannot enjoy their political justice. So there are a lot of issues with respect to that. Let's say what bank policies you might have been heard in various newspaper. Then let's say, for example, the panchayat patis. So these are the issues that are burning in the Indian polity, which ultimately talk about this social order, social, economic, and the political justice. And that is why, as I already told you, that the Supreme Court has allowed the subclassification of what? SCs and STs. And various government, the state government has implemented this. Let's say recently the Haryana government has created a one-man commission, and they have bifurcated their 20% of the quota of 20 into the two halves. One for the backward class and another for what? The most backward class. Why this is so? Because it says that the equality of the status and the opportunity. So, see, there must be equality, but equality must be among the equals. Equality must be among what? The equals. And what the D.Y. Chandrachud, the Chief Justice and the lead judge in this 7 batch judge, has said that the most backwards have not taken, or they have not tasted the fruits of reservation. And that is why this subclassification is the constitutional. Now again, there will be various issues, like it will be a partition of scheduled caste within the communities, or it is like this concept is not being implemented as it is the against of let's say, for example, the vision of Dr. B.R. Ambedkar or the vision of the Indian Constitution. It is a matter of uh, the discussion, but as the Supreme Court has given this landmark judgment and many of the state is implementing it, though I would say that it rather become a political in nature, though uh, like judges has identified that this should not be a political issue, that is a social issue. We have to remove the social inequalities among the most backward. Do not make it or do not politicize it, right? But as and when, let's say, the elections are coming on, and based on the representative of this, the communities, the the parties are, let's say, promising about the subcategorization or the subclassification. And the most important aspect is what? The fraternity. It means the brotherhood. And the, the kind of the issues that I have mentioned over here is, which is ultimately what uh, diminishing the factor of the fraternity, the casteism, the regionalism, the sectionalism, and the violence. The violence might be a political violence or it may be a communal violence. I talk about the regionalism, like one actor from the south, he says that I am not a South Indian, but I am an Indian from South. So what it talks about, it talks about the fraternity, the brotherhood of being Indian, not being a South Indian. So it is very necessary of the citizen, it is very necessary for the citizen of the country to foster the fraternity, to assure the dignity and the unity and integrity of the nation. And finally, I'm just summarizing this with some Supreme Court judgment that whether the preamble is amendable or not. So you see that in a Berubari Union case, this case was related to the Indo-Pak agreement, where there is a Berubari Union that is need to be that was an area rather, and that is need to be divided half between the India and Pakistan. It was famously known as a Nehru-Nun agreement. Okay, and when I say when you see the RE and what it means by RE on any particular case, that this case is being referred by the President of India to the Supreme Court under Article 143, because the validity of the law or interpretation of the Constitution can be only done by whom? The Supreme Court of India. And under Article 143 of Indian Constitution, the President is empowered to send any matter that is on a question of a law to the Supreme Court for their interpretation. So when you find this RE, it means that it is being referred by the President of India to the Supreme Court. And in this Berubari Union case, the Supreme Court has given the judgment that preamble is not a part of Indian Constitution. And the reason that they have provided is the preamble is not numbered. Like the numbering of the article will start from Article 1. That was in Part 1. So in Part 1 we have Article 1 to 4. In Part 2 we have Article 5 to 11. In Part 3 we have Article 12 to 36. In Part 4 we have Article 37 to 51. So preamble is not a numbered as like the article, and that is why the Supreme Court held that preamble is not a part of Indian Constitution, and that is why it cannot be amended. And the judges of the Supreme Court says that the preamble is a preface, not the enforceable or the amendable. Enforceable means if anything that has been written in a preamble, if it is not being implemented, then you cannot approach to Supreme Court, right? But one more point that has been specified in this Berubari Union case is the Supreme Court judges have said that the preamble is a key to open the minds of constitution makers. So whenever you find any difficulties to interpret any particular articles or the provision of the article, you can take a reference of the preamble. And then in a landmark judgment of the Keswanand Bharti in 1973, there was a 13 batch judgment and the judgment has been given on uh, the ratio of 7 to 6. And Keswanand Bharti said that in this judgment, it said that the preamble is a part of Indian Constitution, and hence it can be amended under Article 368, right? But as you know that you should read this Keshwanand Bharti case, which has given the concept of basic structure, right? And that is why in S.R. Bommai case, they have added the secularism as a part of a basic structure, and that is why the preamble is become a part of the basic structure. And in LIC of India case 1995, the Supreme Court held that preamble is the integral to the constitutional interpretation. It means the preamble is the integral part of the Indian Constitution, right? And that is why it is amendable. But as we know that S.R. Bommai has already said in S.R. Bommai case, that has been already said that preamble is a part of basic structure, and any basic structure of Indian Constitution cannot be altered by the Parliament. So I hope you get few information about the preamble. However, this is not the complete information on the preamble. You must need some extra readings. You have to read some articles that relates to any of the keyword that is being provided, and what you can do is you can try to answer these questions. That might be a possibilities that this question, out of this, some questions might get asked in exam. There are some questions that has been asked already in various mains examination, like as I already told you, that discuss the India as a secular state and compare it with the principles of US Constitution. They have already asked in 2024, and the 2 years back they have also asked what the France should learn from the Indian secularism, right? So you can take some any recent issues with respect to that countries. You can rather read that articles, and accordingly you can make your judgment. So that's it about preamble, and I hope you get the information, and you should have to write these answers to actually understand the concept of preamble. Thank you so much.